first set of visas we are going to discuss deal with visiting the United States. We receive calls from people all over the world who are stuck outside the country and can't manage to get themselves in. High-speed summary. Persons from Mexico have the border crossing card. Most countries are eligible for the B1 visa, visitor for business, as well as the B2 visa, visitor for pleasure. But only some countries are eligible for the 3-month visa waiver, primarily those in Western Europe as well as Australia. Now, let's start at the beginning. There are 4 ways of entering this country. There is the border crossing card if you are entering the United States from Mexico. It's a machine-readable document form called the DSP 150. It allows you to enter up to 25 miles from the border for a maximum period of 72 hours. It is for persons who are citizens or permanent residents of Mexico. The rest of the world can enter with a non-immigrant visa, such as the B1 or B2. Now let's discuss these visas and what's involved so that you can enter the United States. We will start with the B2 visa, the visitor for pleasure. Everyone can apply for these, regardless of country. This is an important section because we will start by explaining some legal principles that will really help you. They apply not just to the B2, but to many other types of cases as well. The first thing I'm going to tell you is that you must be able to provide a solid case up front when you are trying to enter. Why? Because there is no appeal. Appeal, for those of you who do not know, means second chance by the same set or a different set of eyes or higher authority. If you are denied a visitor's visa, you're stuck somewhere else and cannot enter the U.S. There is something that most people are not aware of, called a motion to reconsider. A motion to reconsider is a legal document that you present to the CIS, also called the Immigration Department, the United States Citizenship and Immigration Services, CIS for short, or embassy. You're asking the government to re-examine your case. You're stating in your file, I want you to look at this again for these reasons. Or a motion to reopen and reconsider, which states, I'm adding new evidence which I perhaps forgot to mention the first time around and I would like you to reconsider. Do that in 10 days while the case is fresh in their minds if you can. It should be done within a maximum time span of 30 days. By the way, 30 days means the government should receive it in 30 days. This is not a postmark date. They have to physically receive it by that deadline. Sometimes you can take an old case, reopen it, and have it reconsidered. Here's an example. Someone was trying to enter into the country on a B2, which is a visitor for pleasure visa from Poland, and had been trying unsuccessfully for 6 years. We filed the case and were denied. We were surprised because we felt there was a case that should have been approved. We called the officer to discuss the case. We prepared and filed a motion to reconsider, and it was approved. The client was so happy she was in tears. It's a great mechanism. This opportunity exists, but there is a catch. One client tried to obtain a visa on his own and failed. He then hired us to prepare a motion to reconsider. His local United States embassy stated no law forces them to accept these motions, and they simply won't consider them. So, if you prepared a poor case with that embassy, and had the bad luck of depending upon that embassy, you'll possibly never see the U.S. unless you find a different mechanism. You're stuck there. Only one embassy we've ever dealt with has been like that. You'll be happy to know. Another important detail. Once you submit a visa application, you cannot withdraw it. So be very careful what's on there. Make certain all the information is accurate. It is the best advice I can offer you. Your record can last a very long time in this business. In order to make an appointment with an embassy or consulate for a visitor visa, you go online. They all have websites and explain the procedures. For some of them, you have to call a phone number from within your country and you cannot call from the United States. They may charge you by the minute for the call. You make an appointment. Some of them will have different methods. Then they will want you to pay somewhere around $100. They usually have specific instructions such as deposits in certain bank accounts or money orders. Do what it takes. It's very simple. When you go to the appointment, you are going to fill out a form, a DS-156 and possibly a DS-157. They're both on our website, immigrationhousecall.us. What you are going to present in order to offer a solid case is of utmost importance. Act like you won't get a second chance and you will do a good job. Too many people don't take these applications seriously, and they call an attorney when it's too late to do anything, or they've ruined their chances for entering. Unfortunately, everything will be kept on file for a long time. Before we go on, I wanted to explain an important document. It's a printout of the Foreign Affairs Manual dealing with visitors. You can find a link to this on our website, immigrationhousecall.us. There are various laws that affect immigration. There is the INA at the top, the Immigration and Nationality Act. Then there are the CFRs, the Code of Federal Regulations. They're like an owner's manual to the law and are very similar to the owner's manual for software. Then there is the Foreign Affairs Manual and a few others. You need to be familiar with at least these three if you are one of these people who like to conduct their own research. But this is actually wonderful. The Foreign Affairs Manual. It explains in great detail all the different sections and allowances. I'm going to discuss them with you, of course, but not at this level of detail, otherwise the presentation would take 2 hours longer. Print yourself a copy of the Foreign Affairs Manual, which can be found on our website, immigrationhousecall.us. Take a look at it. It's not that long and it covers a lot. It offers you a good idea as to what you are able to do and not able to do. There are many other sources of immigration information, but these will be discussed on the website and are the 3 majors for you. We don't want to overload you with information because it can get confusing. There are various types of persons that can use the B2 visitor visa. For those of you who like to research and read, go to the Foreign Affairs Manual in Section 9, subsection 41.31. Again, you can link to it from our website, and it's called the B2. To give you an idea of the range of people who can enter as visitors for pleasure, you have people who are dependent members of families of the armed forces, participants in social events, amateur athletes, and entertainers. They even have special sections for still photographers, musicians, participants in special cultural programs, certain international competitors, and of course, tourists. If you have a criminal record, sooner or later they will discover it. They're discovering information about records worldwide. In this case, what you want to do is have an attorney prepare what is called a waiver for you. That is where you state to the government, I've done these things you don't approve of, but for these reasons. Please overlook them and let me in. We will discuss them in much greater detail later in the last section of the program. With respect to the B2 visitor, not to mention almost every other visa, Section 214B of the INA, or Immigration and Nationality Act, is important. Basically, it states that an intending immigrant shall not be granted a visa. So, when you are trying to cross that border, you are viewed as a potential immigrant. A visitor is not an immigrant. A visitor is called a non-immigrant. An immigrant is someone who wants to live in the United States permanently, or at least not on a temporary basis. It's your job to show them you are a non-immigrant, and you intend to leave when you complete your stay. What kinds of people are most suspicious? Well, put yourself in the shoes of the immigration officers. Who would you turn down? Young people have a problem because they do enter and overstay. People of all ages overstay. Not just young people, but also people with little education, no career, no family to return to, and no ties to their country. They figure these people are more prone to taking risks. If you are young, show them that you have a career back home, a university education, or you own a house. You are going to have a bit tougher time if you have few family members you are leaving back home. I choose to make young people an example because they make up a big proportion of the visitors coming to the U.S. Here's a real-life example of what looked like an intending immigrant situation, but wasn't.